Good afternoon once again, everyone. My name is Jeremy Glover, and it's my pleasure to welcome you to our latest Fenwick Elliott webinar. I'm very pleased to be joined by two of my colleagues at Fenwick Elliott, partner Claire King and one of our senior associates, Rebecca Ardagh. Having worked with both of them, I know they're perfectly placed to provide some excellent practical advice on the topic. We'll also be providing you all with a link to the slides that you see this afternoon. So Claire, Rebecca, I'll leave the stage to you.
Thanks very much, Jeremy. As Jeremy explained, today Rebecca and I are going to be looking at conditions precedents. What is a condition precedent? What is the definition of a condition precedent? Where do we commonly find them in construction contracts, and what commercial purpose do they serve? When will a condition precedent be enforced? And Rebecca is going to take us through some key case law which will allow you to analyse whether a clause is in fact a condition precedent, i.e. it's mandatory or not. I'm then going to look at some further case law on time bars, a subset of conditions precedent clauses, and look at what determines when those are likely to be enforced. We're then going to look at some key provisions in the NEC, FIDIC and JCT forms, the effect of which is sometimes disputed and has been subject to a lot of case law. And finally, we're going to draw those various strands together and look at what sort of arguments you may want to consider if you're seeking to argue a condition precedent provision does or doesn't apply in your particular contract. What is a condition precedent? It's a contractual stipulation that must be satisfied before a right or obligation comes into existence. There are different types of condition precedents. There may be a condition precedent to an agreement coming into effect, for example, i.e. you have to have funding in place, or perhaps planning has to be obtained before you can start works. So if that condition precedent is not satisfied, then there is no agreement unless that condition precedent has been waived. Those provisions with time bars attached to be used in construction and EPC contracts, as you will know. There may be condition precedents to claims to an extension of time or loss and expense that give you notice within a certain period of a delay event occurring. There may be a condition precedent where there's a change of scope, and if you don't give notice in time, again, you may not get any further money, even if you do the work. There are also gateways to the next steps in the dispute resolution process. For example, you may need to issue a dispute notice, have a commercial management meeting before you can take the next step and start an arbitration. And they're a useful management tool when used properly. So, conditions precedents as a management tool. Prompt notification allows prompt evaluation of claims. That is the theory. And the parties can work together to manage the risks more effectively if you comply with these provisions. That is always obviously in everyone's interests. Similarly, if you can't afford, if an architect's instructed a variation and it can't be afforded, then they can make the decision perhaps they don't want to carry on and instruct that after all. They also theoretically stop the build-up of claims, the souring of relationships, and the final account dispute at the end of the job. So their role is clearly recognised by the courts, and this is a theme throughout the case law on these sorts of clauses. And just to quote from Mr. Justice Jackson, contractual terms requiring a contractor to give prompt notice of delay serve a valuable purpose. Such notice enables matters to be investigated while they are still current. Furthermore, such notice sometimes gives the employer the opportunity to withdraw instructions when the financial consequences become apparent. So with that in mind, I'm now going to hand over to Rebecca, who's going to look at the case law on when condition precedents will be enforced in more detail.
Thank you, Claire. So conditions precedent can either be a gateway or the barrier to important contractual relief for a party. But how do you know if your relief is subject to one? So generally, what you need to be looking for is a conditional link between the subject and the performance of certain obligations. So is the subject contingent on this performance? So long as that link is clear, it does not really matter what wording is used to create it. So while the words condition precedent are often used, they're not required, which, while it seems generous, can lead to some confusion. If the words condition precedent are not used, it is still important to examine a potential condition precedent carefully. So a potential condition precedent that you should take note of probably will be a notice provision, but there are others. These are particularly in the case of a bespoke contract or an amendment when made to a standard form. So the stages of this examination generally follow the ordinary principles of contractual interpretation. So we're looking first at what is the ordinary meaning of the words, and then how does this ordinary meaning fit within the context of the contract as a whole. Something to consider in particular when moving to an assessment of the contract as a whole is where are these same words used elsewhere in the contract? So if the same words have been used elsewhere in the contract to create a clear condition precedent, then it is likely that the repetition of these words in the clause in question is demonstrative of the party's intention for this clause to also act as a condition precedent. This principle does, however, cut both ways. So in the same way, if the words condition precedent, for example, have been used throughout the contract to create a clear condition precedent, but they are not repeated in the clause that you're examining, then this is likely to be considered demonstrative of the party's intention to have the clause operate as an ordinary contractual mechanism rather than as a condition precedent. So in that case, failure to comply will be considered a breach of contract that may potentially trigger liability for damages, but it will not go so far as to extinguish a right to relief, which I'll discuss in more detail shortly. The courts have accepted that there are other words besides the words condition precedent that can have the potential to form a condition precedent, such as shall be subject to or shall be conditional upon, but oftentimes they can fail at sufficiently establishing a conditional link when the contract as a whole is taken into account. And this was the case in Tullow and Heritage Oil in relation to the use of subject to. So this case concerned the payment of a $313.5 million tax by Tullow to the Ugandan government, which was in relation to the government's consent to Tullow's purchase of a petroleum exploration license from Heritage Oil. Under the sale purchase agreement, this tax was actually payable by Heritage Oil, but given the operation of the Ugandan law, it became Tullow that was liable for the payment. In light of this, and to rectify it, the sale purchase agreement included a tax indemnity provision at Article 7.2. At Article 7.5, it was stated that upon becoming aware of a tax claim to which Tullow was entitled to an indemnity, Tullow shall, under 7.5a, provide notice within 20 business days, and under 7.5b, take such action as Heritage Oil may require to defend or dispute the claim. So, for example, comply with document requests to substantiate the indemnity. So, was the 20-day notice requirement under Article 7.5a a condition precedent? The short answer is no. The slightly longer answer, which I know you are all eager for, is that the court took time to consider the long history of the case law on the subject and acknowledged, as Claire pointed out, there are clear benefits, such as those outlined in multiplex, of enforcing some clauses as condition precedents. In addition to providing parties with ample opportunity to investigate a claim, they also assist, it was pointed out in this place, in creating contractual certainty. However, on the other hand, it can result in a party losing a contractual right for some sort of trivial breach of contract that does not actually prejudice another party or cause any loss. So it was highlighted that there is a general reluctance by the court to enforce contractual provisions as conditions precedent. And in this case, it was found that the balance tipped towards this reluctance for the following reasons. There were clear examples of conditions precedent elsewhere in the contract, as I discussed earlier, and the wording that was used in those conditions precedent was not repeated in Article 7.5a. It was noted that where no such wording was used is marked and of particular significance. It was also relevant that both parties had the benefit of potential indemnities under the contract. So the fact that there was this sort of reciprocity between the parties in this benefit meant that it was in both parties' interest to ensure that their right to this benefit would not be extinguished for a trivial breach. The fact that that was a commonality between the parties was of significance. Finally, the structure and the form of the article was relevant. So in particular, both 7.5a and 7.5b are linked to the wording in 7.5, and it is that wording in 7.5 that contains the word shall. So it cannot follow, they held, that it would be a condition precedent under 7.5a if the operation of 7.5b was not as a condition precedent. Notably, this is different to the approach in Aspen Insurance, where it was decided in that case that the fact that one contractual provision under a grouping of provisions headed condition 4 was not a condition precedent did not prevent another provision under that same heading, condition 4, from operating as a condition precedent. In this case, that was distinguished because in Aspen Insurance, despite the provisions being grouped together, they still remained separate and freestanding provisions, so they could operate independently of each other. In this case, however, there was a common link of Article 7.5 introducing both 7.5a and 7.5b, with the same sentence used with the same wording, that word shall. So when considering whether your cause is likely to extinguish a right to relief in practice, it's necessary to bear the following in mind. Conditions precedent are generally treated as limitation clauses. Therefore, they need to be both express and clear in their intention to extinguish a right to relief. So in Towergate, for example, the clause in question was able to be enforced on the basis that it was clear, grammatical, and workable. So there can be no ambiguity when it comes to the intended effect of a condition precedent. They may also be subject to the same considerations as limitation clauses. So for example, the reasonableness test under the Unfair Contract Terms Act 1977. Another consideration may be whether the commercial purpose of the clause in question justifies its compliance with the clause. So in Aspen's case, the commercial purpose of the condition precedent was to allow underwriters to investigate a claim at the earliest opportunity, and this purpose justified the enforcement of that clause as a condition precedent. That is a common theme amongst condition precedents, the ability to investigate a claim at the earliest opportunity, so it is important to bear that in mind. And then finally, does the clause go further than simply making compliance mandatory? So obviously contracts are full of mandatory terms, the breaches of which do not extinguish the rights to relief, they purely give rise to damages as appropriate. If the intention of this clause you're considering in particular is to go further than simply being mandatory in terms of compliance, and to the extent that it wishes to go to extinguish a right to relief, there is an argument that the clause needs to be clear in stating this. So what all of that discussion can so efficiently be boiled down to in a mere paragraph by Keating is that clarity is key. So as they say, the courts are unlikely to treat a clause as a condition precedent to the making of a claim, absent the clear language to this effect. So now I will go back to Claire, where she will discuss whether notice provision in particular will be considered a condition precedent.
Thank you very much, Rebecca. So when is a notice provision a condition precedent? This is particularly relevant in the context of time bars. So a notice provision should be construed as condition precedent, according to the Bremer versus Vanden case, if it states the precise time within which the notice is to be served, and makes plain by express language that unless the notice is served within that time, the party making the claim will lose its rights under the clause. Now, Bremer versus Vanden is a House of Lords case, but the case law since then has seemed to move on slightly. So just moving on, what is a precise time? If you look at the case of Stereo versus Sigma, that suggests that a reasonable period may be precise enough for the purposes of having a precise time. You might not need a specific number of days to be set out in your clause for it to be a valid time bar provision. So clause 6.1, just to give you a feel, if by reason of any circumstance which entitles the contractor to an extension of time for the completion of the works under the main contract, or by reason of a variation to the subcontract works, or by reason of any breach by the contractor, the subcontractor shall be delayed in the execution of the subcontract works, then any such case, provided the subcontractor shall have given within a reasonable period written notice to the contractor of the circumstances giving rise to the delay, the time for completion hereunder shall be extended. So that is the clause. They looked at it, and as you can see, there's no defined number of days in that clause. So the next slide, again, a bit more justification here. The judge is basically saying, look, we can assess what this time period is, or he thinks you can. So the fact that there may be scope for argument in an individual case as to whether or not a notice was given within a reasonable period is not itself any reason for arguing that it is unclear in its meaning and intent. And this is a curious case. It slightly sits at odds with Bremer, which is obviously a House of Lords case, while Stereo versus Sigma is a TCC case, but is one you have to have in mind. You also have to have it in mind in relation to the second limb of the test that was set out in Bremer. So, express warning for non-compliance. Again, in this case, there wasn't really something saying, and if you don't give that notice, then the consequences are. But the judge said that didn't matter. You didn't need to say that expressly because you could make it out from the circumstances. And again, just reading the judgment, you don't need legal boilerplate in his opinion. So this again is something you need to be aware of, this case, when you're assessing whether you've got a clause that is a condition precedent or not. You have to look at things in the round. And he held that in this case, clause 0.6.1 was a condition precedent. And he did that despite the harshness of the decision. So just moving one slide back. So in overview, just to summarise, where condition precedents are clear, they will be enforced under English law. And this Northern Irish case is actually quite a good example of where that can result in a harsh decision, but the judge still goes ahead and enforces it. This was a PFI project for the upgrade of sludge treatment services in Northern Ireland, very glamorous. It was accepted here that the relevant clause was a condition precedent, and the question was whether the claimant had notified the claims made in the proceedings as required under that clause. Now, it was held that they hadn't. A letter written in connection with a separate but related compensation event, which appeared to identify the breach upon which the claim was based, wasn't sufficient. The event had not been notified explicitly and the notice was not sufficiently clear. So he enforced it despite the potential harshness of the result of the clause here. So, as you can see in the bolding, the contractual terms are clear and commercial certainty is an overarching consideration. So that's something to have in mind as we move in to looking at the standard forms. So the first standard form we're going to look at, Rebecca, would you mind moving my slides if that's okay, sorry, is the NEC standard form. And we're going to expressly look at the NEC 3 time bar provision in clause 61.3, which seems to be generating quite a lot of disputes. Certainly, I'm seeing quite a lot of disputes on this at the moment. Just to read it out so everyone has it in mind, the contractor notifies the project manager of an event which has happened or which he expects to happen as a compensation event. If he believes it's a compensation or the project manager has not notified of it. And he has to do 8 aware of the event unless it arises from instruction, issuing a certificate, changing an earlier decision or correcting an assumption. So just breaking that down a little bit on the next slide. The first thing to check is obviously whether the compensation arises out of any of the following exceptions: an instruction, a certificate, changing an earlier decision or correcting an instruction. So does the time bar apply? Sometimes there's a debate about what is an instruction. We all know that just because something says it is not an instruction or doesn't say it is an instruction, it may still be an instruction. And I've certainly had disputes surrounding those sorts of arguments. You need to look at the document in the round and make a decision as to whether it is an instruction. If you are in any doubt, then obviously you need to notify. Who needs to be aware of the event? There's sometimes a debate as to how senior up the chain of command the awareness needs to go. It's very unlikely that you're going to be succeeding in an argument that the board has to be aware of an event to have to notify this, but there may be levels within the site sort of level of command that maybe you can make that argument you need to check. Time starts from the event, so if you have any doubt that this may cause a problem, delay or a cost, then you need to notify it. Don't wait to see what the impact is and then notify it, because 8 weeks can go very quickly. And finally, has there been some sort of waiver or stopple or gentleman's agreement? Don't worry, we'll see you by this later. We'll deal with the time issues later that you could rely on. And we're going to look at that a little bit later in the talk, so I won't go into too much detail here. And finally, in the context of NEC time bars, one thing to consider is the provisions in clause 10.1. So just moving on to the next slide. The employer, the contractor, the project manager and the supervisor shall act as stated in this contract and in a spirit of mutual trust and cooperation. How does that impact on the clause of 61.3 time bar? Well, there's some interesting case law, Costain versus Tarmac on this. It doesn't actually relate to the 61.3 time within the dispute resolution provisions of this contract. But it makes it clear that as well as having an obligation not to mislead, a negative obligation, it's also a positive obligation on the part of the defendant to correct a false assumption where that's being relied on by someone. So it's quite a useful provision potentially, and it ups the level of your duty to sort of not mislead people as to whether you're going to rely on this time bar. But again, you don't really want to be in position of having to rely on this for your argument or any waiver or stop argument you want to be notifying. So moving on to FIDIC, Rebecca.
Thank you. So in discussing FIDIC, we're going to be focusing on the 1999 form, given that is the most prevalent still in terms of its use, but also in terms of consideration by the courts for the cases that we're going to be looking into. Examples of the various conditions precedent contained in the standard form, employers' claims and contractors' claims are set out in the slide. And so far, I think both of us have managed to not mention the current climate, and I'm really sorry that I'm going to now, but it is likely that you have force majeure and in particular force majeure notices on your mind. So under the 1999 FIDIC form, force majeure is dealt with by clause 19.2, and that under clause 19.4, subject to a contractor providing notice under 20.1, there could potentially be a claim there for time and limited money. So therefore, consideration of subclause 20.1 is relevant when considering a force majeure notice under 19.2. Also just be aware that in the 2017 form, that is clause 18.2, though they do operate in similar ways. When it comes to contractors' claims under clause 20.1, it is necessary to discuss a RASCN. In this case, the FIDIC Yellow Book was used, though slightly amended, as the general conditions of contract between the Government of Gibraltar and a RASCN for the construction of a new road and tunnel under the runway of Gibraltar Airport. For this project, the commencement date was 1 December 2008, with a time for completion of 24 months after that, so 1 December 2010. By October 2010, however, only a quarter of the works had been completed, so there were significant delays. The contractor attributed these to unforeseen ground conditions as well as weather issues, which were, amongst other things, many other things, the issues dealt with in this case when it comes to claims for extensions of time as a result of each of these issues. So under subclause 20.1, a contractor is required to give notice of a claim for extension of time within 28 days of becoming aware of the event or circumstance giving rise to this claim. Failure to give this notice will result in the time not being extended and the contractor losing the right to payment. So did Mr. Justice Aiken consider this to be a condition precedent? Although he did state that the clause should be construed broadly rather than strictly against the contractor, which will give some comfort to the contractors, it was determined that this subclause does operate as a condition precedent. Subclause 8.4, which deals with the contractor's entitlement to an extension of time, and specifically states the fact that this entitlement arises to the extent completion is or will be delayed, influence the interpretation of the application of the notice provision in 20.1. Essentially, in light of the fact that this entitlement was triggered to the extent completion is or will be delayed, the judge concluded notice did not need to be given until there actually is delay. While there is no particular form of notice required by subclause 20.1, this also was construed in the context of the contract as a whole. And so by virtue of clause 1.3, it was concluded that the notice will need to be given in writing. Further, in order to be considered a notice under subclause 20.1, reference will need to be made to the fact that there is delay, and the notice will need to make clear that a claim for extension of time is being made. It is likely that these principles brought through in the Raskin case will be considered to apply for other claims under subclause 20.1 as well. So even though this case was specific to claims for extension of time, the same provisions as to form of a notice are likely to apply for claims for payment as well. Turning now to provisions for employers' claims, the inclusion of notice provisions for employers' claims with clause 2.5 is certainly contractor friendly, and I will say probably less common for conditions precedent, as it acts to prevent an employer from summarily withholding payment or unilaterally extending the defects notice provision. In particular, the employer does not have a general right of set-off as a result of this clause. So in terms of the operation of clause 2.5 as a condition precedent, this is discussed in NH International and National Insurance. So in this case, the Privy Council considered whether an employer's claims for common law rights of set-off and or abatement of legitimate cross claims were barred, given they were not made in accordance with subclause 2.5. The Privy Council noted that the purpose of subclause 2.5 is to prevent such claims unless they have been the subject of a notice. Therefore, to allow such claims without the employer having complied with the notice provision would effectively render clause 2.5 meaningless. The clause itself uses the words in relation to time frame as soon as practicable. The lack of specificity here did not prevent the clause from operating as a condition precedent. The Privy Council went so far, actually, as to say that where the employer has failed to raise a claim as required by the earlier part of the clause, then the back door to set off or cross claims is as firmly shut as the front door of an originating claim. Notably, to finish off, in the 2017 edition, subclause 20.3 allows the engineer to waive the time limit if the engineer considers that, in all circumstances, it is fair and reasonable that the late submission be accepted. Though it looks like a way to argue around the application of the condition precedent of 20.1 in the event of a failure to notify, it's important to keep in mind that the circumstances that the engineer can consider are limited to those contained within the subclause. Therefore, the operation of this potential loophole is still quite restrictive and should not be relied upon by anyone as a fail-safe. And as usual, the best bet is always timely notification of any potential claim. So with that, I'll hand back over to Claire, who's going to move into JCT.
Thank you very much, Rebecca. So JCT 2016, regarded as more contractor friendly than some other forms. The JCT drafting committee have expressly stated, or one of their members on a blog, that they did not intend notification of relevant events or relevant matters to be the subject of a condition precedent, but we still see disputes about this. Clause 4.20.1, it's sometimes argued it is a condition precedent, and it does contain the word shall, which is contrasting to the JCT 2011 word of may, but then again, it doesn't have a precise time period, as Bremer, for example. So the sensible position is notify sooner rather than later, and also with JCT, obviously, there are always, very often, bespoke amendments imposing clearer time limits on this provision and on the relevant events provision, so always check your specific contract. So Will they bite? Just to sort of draw all the strands together, we want to think about things to think about when you want to rely on a CP or try and argue around it. Sorry, I'm having a little problem with my slide control. So, has there been some form of waiver or estoppel? What do I mean by waiver? Well, it's conducts or words indicate enforcement of condition precedent or time bar will not be sought. The person waiving the right to rely on it must know it exists, and there must be communication of those to the person seeking to rely on the waiver. For example, don't worry about notifying I will see you right, or we will deal with the delay claims separately at the end of the project. So related to waiver is the concept of estoppel. Has something been done or said which the party seeking to rely on the estoppel has relied on to the detriment? And just to give you a flavour of how this can work, City versus Shepherd is a good example. The contract required Shepherd to give details of the impact of an architect's instruction within 10 days of an instruction, or lose their entitlement to an extension of time. Now, at a meeting, representatives of City Inn were silent about this time bar, and the claims were discussed there. And the court noted that defenders must be taken bound to know the terms of their own contract. It's a Scottish case, so the wording's a little bit unclear, but basically, you should know what's in your own contract. And it was held that the time bar clause was waived by conduct, and there was no need to show that being prejudice. And just taking a little bit from the judgment, it should also be recognised that following the meeting on the 8th of April 1998, the respondents continued for many months to pursue their extension of time claim based on the gas venting instruction, despite the fact that had clause 13.8 been operated, such a claim would have been barred from the outset. So an example of waiver in operation. So just moving on, what about the contents of the notice? This is something to keep in mind, not just has it been served in time, but what does it say? And sometimes this can come back to bite you a long time down the track. So Mida Corporation versus Bauer Hong Kong, there were various tunnels being constructed for the Hong Kong to Guangzhou Express. Bauer was a diaphragm wall subcontractor. And clause 21 required two notices: notice of intention to claim for extra money or time within 14 days, and a notice within 28 days of the first setting out contractual basis. They had to set out the contractual basis together with full and detailed particulars and evaluation of the claim. Now, the arbitrator decided that the contractual basis of the claim did not need to be set out in the notice. It did not need to be the same. They basically changed their argument by the time they got to the arbitration. But the judge held that the arbitrator was incorrect. You did need to put at the head of claim the correct one in your notice. They failed to pay heed to the express term, which included a statement that the provisions had to be strictly complied with. So this is a bit of a contrast to Mr. Justice Aikenhead's approach in Abrascon. But the moral of the story is check that you are notifying the right thing. Read what you are meant to notify. If it's a contractual basis, be sure that you're drafting something that's wide enough that may capture other bases of claim you perhaps haven't sort of thought about clearly enough, but just try and get it widely drafted and cover everything, every possible nuance. So finally, consider the governing law. In an international context, this is obviously, well, you just have to do it, obviously, but it's something to think about because sometimes it throws new ideas up or ways around arguments that you may not consider if you're just looking at plain English law. So, for example, the Romanian Civil Code and a lot of civil codes have a good faith obligation, and that's just setting out Article 14 of the Romanian Civil Code. That's a good faith obligation, sort of similar to the NEC clause 10.1. So you want to think about whether that could assist you with a similar claim to waiver or estoppel in the common law. But the civil code also imposes obligations that act in accordance with the contract. So they're not get out of jail cards for you to rely on. You need to assess everything in the round. Another thing to check is, does the time bar comply with any mandatory limitation or prescription periods which they a shorter period or a longer period in the governing law. Always something to check in an international context. So, conclusions. Always consider whether a bespoke clause is actually a condition precedent, and look at the case law on it. Rebecca went through the case law subject to condition precedent condition. You need to assess the contract in the round and look at what your clause actually requires. Clear conditions precedents will be enforced under English law, that is very clear. So the message as ever is don't hesitate to notify. Conditions precedents are in contracts for a reason. They help manage risk and prevent larger disputes in the long term. So in that honeymoon period at the beginning of a job, don't be shy. You've all signed up to this contract, comply with it. And gentlemen's agreements are often difficult to evidence in retrospect. Finding something in writing that's as clear as you remember it being can be very difficult. So don't rely on them, notify. Finally, label your notice clearly as a notice and follow the contract wording. Check what you have to notify, because the contents of your notice could bite you way down the line when you're in an arbitration or in a court in front of the Hong Kong court, as they did in the Barra case. So things to think about going forwards. Thank you.
That's brilliant. Thank you, Claire. Thank you, Rebecca. And Claire, your point at the end about gentlemen's agreements. We found ourselves in an arbitration about 18 months ago, simply because there was a gentleman's agreement, but there was no evidence of it, and so there was no means of actually resolving the dispute without having to go to a tribunal. So it's a very important point. We've had 2 or 3 questions. Happily, a couple of them have been general questions about waiver and a stopper, which I think you dealt with quite clearly within the talk. I've got a slightly more specific one, Claire, about the FIDIC contract, and it's reference to subclause 8.9 and the fact that apparently, and I think this is correct, the FIDIC guide says that the 8.9 notices are not time bound. How does that fit in with what we've been saying about the condition precedents? I mean, if on the one hand it's not a time bound clause, but is it still going to be sort of caught by a condition precedent?
Well, this is a question submitted in advance, actually, and I had a look, and this clause is both referred to clause 20.1. My reading of it is that if you have a claim for time or money, you need to notify within the time limits on 20. If you don't, then you don't have a time limit on you. But if you do, notify within the time limit, the 28 days.
Yeah, thank you. Just to repeat what Claire was saying, because you were breaking up a little bit on my screen, I think in a similar way to Rebecca was talking about the force majeure notices, if you under 8.9, if you want time or money, you have to go through the 20.1 process, and therefore you're going to be caught by the condition precedent. Perhaps Rebecca, sort of turn to you. Does a condition precedent have to expressly identify itself as such, or can it be somehow implied?
It would be really helpful if it did have to expressly identify itself as such. I think that would save a lot of hassle, potentially a few costly arbitrations or court cases. Unfortunately not. So it will be taken, as discussed earlier, from a combination of the wording and the contract as a whole. So the wording itself does not have to expressly state that it is a condition precedent, but like we've pointed out and Claire said recently, in order to be enforced as a condition precedent, it's likely that at least the English courts would require the wording that is used to be extremely clear that that is the intention. Even if it's not expressly stated, we need that conditional link.
Okay, excellent. Claire, you mentioned the Romanian duty of good faith, and you also discussed, and I think you made the link between sort of NEC talks about spirit of mutual cooperation, etc. How does that really link with the sort of the condition precedent? I mean, there is a view that a condition precedent isn't fair, but you might still find under a civil code or under the contract, for example, NEC, there is obligations of fairness.
I mean, basically, well, certainly in English law, the condition precedent will stand. It is a condition precedent. The only place that a 10.1 clause may assist is if somebody in a meeting or an email or by their conduct has suggested that they're not going to rely on it. I think in that instance, as an argument, it imposes a slightly higher obligation not to mislead people about what you're going to do. So if you have a gentleman's agreement, agreement, as it were, but you still need evidence of that. So in a sense, it doesn't take you that much further. But I think it does assist you. It's just a little bit higher of a test.
Yeah, I mean, I think I agree with that actually. It's all about being a code of conduct, which I think does give you a little bit of leeway. But you know, as Rebecca's been saying, you need to follow the obligations of the contract. So do give notice and do notify. I'll start wrapping things up now. Just with one other question. And it's a contract where there's a condition precedent to supply collateral warranties, and that's a precedent to payment. Now, the issue in question is that some of the warranties haven't actually become due yet, in the sense that the design isn't needed. So you haven't actually reached the M&E stage of the contract, but there's still this condition precedent in relation to payment. And the questioner was asking whether that was reasonable or not. I can see that links a little bit to questions of fairness. I mean, especially under English law, however, I think the question is probably going to be what was actually negotiated when the contract was put together. But I don't know, yeah. Claire, if you had any views on that.
I think, well, prima facie, you'd have thought, unless it's absolutely impossible to get that, and there's some sort of argument that's in impossible term, which I think is unlikely, it probably would be enforced. So I suspect you'd have to have a pragmatic discussion with the other party and say, you know, we didn't think this through, it doesn't work. Do you want us to go ahead and do the next steps? And you'd have to have that sort of discussion. So I think it highlights the need to think these things through before you sign up to them, and make sure that everything you've agreed to do is actually achievable, just from a practical point of view, to go on to the next steps.
Yeah, I mean, I think that's absolutely right. Well, I think we're just about running out of time now. So I just want to say thank you very much again, Claire. Thank you, Rebecca. Thank you, everyone, for attending. As I said, the slides will be made available to you. There's just time to mention that next week, I'll be joined by one of our partners, Martin Ewan, and also Melissa Shipley from 39 Essex Chambers, and we'll be providing an adjudication update. I know everyone will be very familiar that I'm very well aware that the House of Lords, the Supreme Court rather, recently gave judgment in the Bresco case, but there have been a number of other recent developments in adjudication. We want to cover those as well. So hopefully I'll be able to see you all next week. But in the meantime, thank you very much for joining us today, and goodbye.